Right, so it'll all be on the helmet camera, guys, but so I've given them my name and address there because Code G doesn't say anything about date of birth that I could see. Kept trying to rush me and threaten me with arrest if I didn't find the right section of Code G fast enough, because they have other jobs to get to. Well, I said, well, if you arrest me, it's going to take you longer than allowing me to find the right section of Code G, isn't it? And they won't be getting to other jobs. So they're better off just letting me have the couple of minutes that I need to find the right parts.
You got any idea on you at all, sir?
No, sir.
Okay. Have you got any bank cards or anything that can confirm that name with?
Not on me, no.
Okay. Are you going to be known to us in police systems?
Yes.
Lovely.
Yes, this isn't the first time that I've been unlawfully, arrested, actually. I've been unlawfully arrested twice now. Sued both times. Won both times. This will be number 3. I could have not given you my details and just taken the unlawful arrest, but I've got other places to be today.
Sorry. Is it 3 Delta uniform?
Yes. Yeah, my handwriting's not so good.
Right, mine's not much better.
We drop into this encounter midway, and the tension is already high. The auditor is detained outside a job center while PC Brand pushes for his personal details, warning that arrest will follow if he refuses. The officer cites Code G apace, the rule book that requires any arrest to be necessary and proportionate, not simply convenient. The auditor challenges that directly, pointing out that he is calm, cooperative, and not attempting to leave, questioning how handcuffs or arrest could meet the strict necessity test under those circumstances. As the exchange unfolds, the focus appears to drift away from any clearly defined offense and toward quickly securing identification. That shift is critical because Code G is designed as a safeguard against unnecessary detention, not as a tool to speed up administrative processes. The central question becomes unavoidable. Is this detention genuinely required by law, or is urgency being used to justify control? When procedure feels rushed, the obligation to clearly explain the legal grounds becomes even more important. And that pressure is exactly what begins to expose the weakness in the justification.
Have your body cams been on the whole time?
They have.
Is there a reason you didn't tell me?
Was it not obvious?
No.
Really flashing?
No, it wasn't.
Okay.
No.
Well, body cam's been recording the whole time.
So why didn't you tell me at the beginning of the interaction?
I'll be honest with you, I forgot.
Right.
However, we've been having a conversation. I think we've been fairly reasonable and
I don't think you've been reasonable at all. Amicable, yeah. Not rude, but I don't think you've been reasonable, no.
How would you say I was being unreasonable?
By the fact that you won't take my complaint against them. You're happy to take their complaint based on 3 allegations where you haven't reviewed any footage, any evidence. Okay. Whereas I'm saying I will show you the evidence of him calling me a TWAT, but you won't take my complaint. That's not reasonable, Constable.
What my preference is, okay, we get you away from here, get you outside, and then I'll listen to your side of the story. At the moment, we've got one version of events where an allegation's been made, obviously, which is why I've requested your details and the offence that's been allegated. I'm more than happy to take your side of the event.
Oh, now you're happy, yeah, okay.
Okay. I'm trying to be. I'm trying to explain to you that I want to get.
Well, earlier, you're saying you weren't going to take mine today.
No, I wasn't originally. And if you're telling me that you can show me, potential footage that may.
But you didn't ask them to show you potential footage.
Because, like I say, I've got 3 witnesses telling me that.
You don't think 3 security guards are going to club up?
Story, do you? You just want to put your own point across.
Okay, go on. You got 3. Yeah, you got 3. You got 3 witnesses.
Witnesses who have all told me that you've said things to them which aren't very nice, which is a public order offence. Okay.
It's not though, is it?
It is. Section 4 of public order, yes. If it's caused them harassment, alarm, or distress, yes, it is. Okay, and I think you know that as well, don't you? Which is why I've requested the details.
It's got to be threatening, abusive, isn't it? Language.
Or visible representation.
Or visible representation, yes.
Yeah. So abusive, I would argue what you've said is abusive.
Is it? How do you know? What have they told you that I've said?
Like I say, if it does go that far, you can discuss that in interview.
Okay.
If they make a formal complaint, you'll be invited into a voluntary interview.
Okay.
And the investigating officer can discuss that with you there.
That's fine. Well, yeah, once we're done here, I'll show you the footage of him calling me a TWAT, and then I want you to come get his details as well and do the same thing with him.
The officer acknowledges that his body-worn camera was not activated at the outset of the encounter, which immediately raises questions about transparency during the critical early moments. More concerning is his refusal to review the auditor's footage of the alleged assault by security, while appearing willing to rely on the security guard's account without hesitation. That imbalance creates the impression that one version of events is being accepted at face value, while the other is dismissed without examination. Policing standards require officers to pursue all reasonable lines of inquiry, especially when conflicting accounts exist. Declining to consider readily available evidence, particularly video footage, risks undermining perception of neutrality. The key issue becomes whether the investigation is being conducted impartially, or whether conclusions are forming before all relevant material has been assessed.
Yeah, fine. Also, a member of the public that was in here earlier calling me see you next Tuesday multiple times.
Can I just confirm your second name? Is it UM?
Pardon?
Is it UM at the end?
Your mother, yeah, Mike at the end, yeah.
So Uniform Mike?
Yep.
Okay, unfortunately, Dominic, you're not coming back on our systems at all. It might be because of your address where you're based.
Try it with.
If I can get your date of birth.
Try it without room 1.
No, what I'm saying is because you're in West Mids, this is a Cambridge address, isn't it?
Yes, yeah.
So because you're in West Mids, we don't have access to Cambridge addresses or anything like that. So I can't confirm your address at the moment.
Well, can you not call through to Cambridge and be like, I can literally give you somebody to contact at Cambridge who will confirm who I am.
Who would that be? I also can't confirm your name.
Huh?
I also can't confirm your name.
What do you mean?
I can't confirm who you are because you've given me a name written down on a piece of paper. You've got no ID and you've not given me a date of birth. So at the moment, I can't ascertain what your name is.
The officer suggests that a Section 4 Public Order Act offense may have occurred, an allegation that, in law, requires conduct that is threatening, abusive, or insulting and intended to cause another person to fear immediate unlawful violence. That threshold is specific and fact-dependent. What makes this moment controversial is that the officer has not personally reviewed any footage or direct evidence, yet his warning of arrest based largely on a third party's account. Acting on information from others is not automatically improper, but must still amount to reasonable grounds grounded in objective facts. If the evidential basis has not been assessed and the legal element of the offense have not been clearly articulated, then threatening arrest risks appearing premature. The key question becomes whether the suspicion genuinely meets the statutory criteria, or whether the reference to a serious offense is being used to secure compliance before the facts have been properly established.
Because you're not coming back on our system.
What if I can show you a bank statement on my phone with my name and address on it?
It could be anybody's bank statement.
You can literally watch me log into my bank and get it.
If we could just get your date of birth, that'd be a lot easier, to be honest.
Give me a pen and paper then.
Okay.
Am I detained at this point, by the way?
On suspicion of the offence, yes. Whilst I ascertain your name and address, yes, you are.
And what section is that you're using for the detention?
I don't know. I'm sure you can look it up on your phone.
No, if you're going to detain somebody, you need to know what you're detaining them with. PC brand. I'll ask you again, what are you detaining me under? What section are you using to detain me? I've given you my details.
Just bear with me a minute.
No, I'll keep talking. You don't have to listen if you don't want to. You got me on there?
I think we have, yeah.
Yeah, there we go.
Just confirm where you were born for me.
You've got me on there, Constable. I've given you all my details. They all match up with the system that you've got on there, and I said I would be known to you.
The exchange turned precise and technical at this point. The auditor asked a direct question. What power are you using to detain me? Under the Police and Criminal Evidence Act, PACE. When exercising a stop, search, or arrest power, officers are generally expected to clearly state the legal basis for that action when reasonably requested. The ability to articulate the specific section is not a formality. It demonstrates that the power being used is grounded in statute rather than assumption. When the officer hesitates or struggles to immediately identify the relevant provision, it raises concern about whether the detention is properly anchored in law. If an officer cannot clearly explain the authority they're relying on, the legality of the detention may be called into question, because lawful powers must be both justified and capable of being articulated at the time they are exercised.
I don't need that. I've given you everything that you need.
Lovely stuff. Okay, wonderful. What we'll do, I'm going to keep hold of this because I need to stick some on systems later on.
Well, you've just got it on there, haven't you?
Yeah, I'm going to keep hold of it either way. It's easy for me. It's just easier access.
Well, I don't know what you're going to do with that bit of paper. What if that gets lost? What if that gets put in a random bin and somebody else finds it?
I can assure you we've got shredders at the office that will
I've seen the way that police hand someone private information.
Okay, I'm going to ask you to leave the premises now.
Right.
Outside. Presumably you've got a vehicle because I can see you've got a motorcycle.
And the purpose for asking me to leave again?
Prevent a breach of the peace.
And what breach of the peace do you suspect would happen?
Based on the fact you've been abusive to the staff here, I don't want anything to.
It has to be, a breach of the peace constitutes physical threats or actual violence to a person or their property in their
Being
presence.
abusive to somebody could also constitute.
I've been sat here peacefully, Constable. They're the one that surrounded me and attacked me.
Breach of the peace. Okay, so what I'm going to ask now is for you to leave the premises, please.
And if I don't,
Okay, I need you to leave the premises.
okay, and I'm asking what happens if I don't?
I need you to leave the premises, or we'll have to forcibly remove you from the premises.
Using what power?
The situation raises further concerns when the officer recorded the auditor's personal details on a loose scrap of paper, prompting questions about proper data handling and compliance with information security standards. Moments later, the justification shifts again, this time to a breach of the peace. Legally, breach of the peace is a common law power intended to prevent imminent violence or harm, not to manage routine disagreements or enforce civil trespass issues. It is meant to address situations where there is a real and immediate threat of disorder. When that power is invoked without clear evidence of impending violence, it risks appearing as a fallback option rather than a proportionate response. The key issue becomes whether there was an actual imminent breach to prevent, or whether the power is being stretched beyond its intended scope.
To prevent a breach of the peace.
And that's
Public Order Act.
That's not a Public Order Act, is it?
It's
not.
Okay.
That's common
Is there
law.
anything
Oh
I can
wait,
say
actually,
or do
no,
to make
maybe
you reasonably comply with my request?
maybe it has been in the new Public Order Act, actually,
So
isn't
I'm
it?
going to give you one more opportunity, please, to leave the premises. Or we'll
Right.
remove you.
Okay, under threat of violence, I will move. Under threat of arrest, I'll give you my details. So under duress, and you guys will be getting lawsuits. Goodbye. Goodbye. I'll stand outside then.
Right, bit further away from them, please, then we'll have a conversation.
I'm a bit stuck. I'm gonna have to go up around.
Okay.
Right.
Do you want to tell me your side of the story, though?
Well, as they said, I went in. I was recording.
Yeah.
From.
In the closing moments, the auditor states that he will leave under duress, and that wording carries legal significance. It signals that he is complying solely to avoid escalation or arrest, not because he accepts that the direction is lawful. That distinction can matter later, particularly in civil proceedings, because voluntary compliance may weaken a claim, whereas compliance under protest preserves the argument that the order itself was improper. By clearly stating he is acting under duress, he creates a record that his departure was not consent, but compelled by the circumstances, an important step if any future challenge is made regarding unlawful removal or misuse of police powers.
Actually, no, I'm not going to give you all that because actually you've taken all my details and you're investigating an alleged offence, so I'm not going to give you any information on that, but I'm going to give you, I want to report the taller one in there, not the glasses.
Which chap? One with glasses?
No, not the one with the glasses, the taller one. He was the taller, that's the one, bold chap. Yeah, referred to me as a twat in public in front of all the claimants in there.
Okay.
Which, again, if they're saying what I've said is a Section 4, that's definitely a Section 4.
Okay.
So if you're going to prosecute one, you had no choice but to prosecute the other. Thank you. That's it. Simple as that, isn't it?
So he's called you a twat. Is there anything
Yeah,
else?
it's called me a twat. The one with glasses has hit me in the forehead with his phone.
Okay.
He's shoved me on the back of the head with his elbow.
Do you know?
Huh?
What was the reason for that?
Don't know.
Okay.
He didn't
We'll
like.
go and have a look at the
He didn't like what I was
CCTV
doing.
and see what it shows.
Oh, I'm going to make a subject access request for that CCTV as well. But yeah, absolutely.
Okay.
But yeah, he's at one point he got his phone out and was asking why. He's asking, "Oh, how do you like it? If somebody's shoving a phone in your face?" That doesn't bother me at all. And then he's getting closer and closer and goes like that into my forehead, clearly on purpose. And then he was behind me, clearly shoved. Multiple times they've tried to grab and detach my camera from my helmet or turn it off. I'm not really sure, but from behind. Again, it will all be on their CCTV. Yeah. The way they've surrounded me and been aggressive towards me is unprecedented. It's ridiculous. Okay? So, but again, you said you don't have time to look at my camera for an hour, but you've got time to go down check their CCTV.
I'm not going to go and watch your footage that you've got on your phone. It's because this job's been open for a while, isn't it?
Huh? I've been recording now for an hour and 20 odd minutes.
So it wouldn't be proportionate in my time to spend.
But you said you're going to go check their CCTV.
I'm going to go and look at CCTV regarding the potential assault you just alleged. However, my suspicion would be that they've used it to maintain control over yourself.
I'm sat on a chair doing nothing.
Enough, and that's what I'm going to go and check out.
Once outside, the momentum of the encounter changes. The auditor formally alleges that a member of security shoved him and struck him with a phone, clearly framing it as an assault. At that point, policing standards generally require officers to record and assess such allegations, especially when they're made directly and contemporaneously. The key issue becomes consistency. If complaint were acted upon when made against the auditor, the same procedural seriousness should apply to his counter-allegation. The officer's response in this moment is crucial because impartiality isn't just about hearing both sides. It's about demonstrating through action that both accounts will be documented, evaluated, and investigated under the same evidential standards.
So if I'm sat on a chair doing nothing and they've come and done that to me...
Absolutely. If you sat on a chair and someone just come and put their hand in your face, then absolutely, I agree with you.
Thank you.
That's what I need to go and check. What I'm saying is I'm not going
to... Literally, as soon as they said they're calling the police, I said, fine, I don't want you coming here and then going around Birmingham looking for me. I said, I'll wait for you because I thought we were going to have no problems because ultimately I may have been trespassing. That's a civil issue, not your problem. But what they allege is ridiculous. Okay? So once it comes back that that's false, right? There's no evidence to support it. Okay? I want you to get them done for wasting your time, making false allegations, interrupting my freedom to privacy. Okay?
Just let me address one thing at a time because I'm not that.
Yeah.
All right. We will call the offence that you've alleged against them as well.
Yeah.
Okay. So ultimately, you're saying he's called you a twat. It'll be a public order as well. So you'll be a victim and a suspect for the allegations that they've made.
Yep.
I won't be the officer that investigates the matter. I'll do a bit of primary investigation here whilst I'm here. I'll be a response officer. So ultimately, I'll go off to a different department and they'll investigate it. And take your phone number, then I can send you the crime number as well. If that's something you'd like to do, otherwise I won't be able to give you that.
You can give me, you can take my email address.
An email address?
Yeah.
This moment highlights a critical tension between individual rights and perceived police convenience. The officer argues that reviewing the auditor's footage would take too much time, essentially prioritizing administrative efficiency over thorough investigation. The auditor counters his right to have relevant evidence considered, including footage that could exonerate him, outweighs the officer's desire to move quickly. Under UK policing standards, any action taken must be proportionate to the circumstances. Ignoring exculpatory evidence or failing to pursue reasonable lines of inquiry risks undermining that principle. The debate raises a fundamental question. Can convenience ever justify bypassing material evidence, or does the obligation to act fairly and proportionally always take precedence?
Probably I get all sorts come up on
Yep.
Lovely. Well, I'll sit down there then. We'll have to.
So there'll be 2 more tyrants for the tube.
What I will say is, obviously, if you're coming back to this location,
Yep.
we'll speak to them regarding what you said. But I don't want you coming back here. If you do come back here, then we'll have to arrest you for the offences that have been alleged. Okay, do you understand that?
Yes.
Lovely. And we will also, there's been a log generated for them to have your name on it.
Yep.
Ultimately, transpires that if you've gone to another job centre or another location in the vicinity and you're doing the same things, you'll be arrested straight away. It won't
For
be a
what?
question. If there's any offences, when they breach the peace, you'll be locked up again.
You can't lock me up for breach of the peace.
Okay.
No, you can arrest me, remove me, and de-arrest me. Or you can arrest me to, what do they call it?
We can take you into custody for breach of the peace.
For what?
That's what you're asking.
For what?
To keep breach of the peace prevented. Especially if you don't live around here, you're giving us no alternative addresses.
So I'm not allowed to go to any other job centres today?
What I'm saying, I'm advising you not. I can't tell you what to do. Okay, you've got your own rights. You're human, but I can only advise you on the basis that as a police officer, if I return to a job and you're there, chances are I'm probably going to be locking you up, especially if there's another alleged offence such as a public order.
Yeah, but again, as you've seen, and sensibly, as a constable, you should be pretty good at assessing situations when you enter a scene, right? You get a call, you enter a scene, you should be pretty good at assessing what's going on. When you came in, what was I doing?
You were sat down.
Doing what?
I don't know.
Doing nothing. Sat there peacefully, chatting nicely to the rather larger guy. I don't want to be rude, but identifying way. Chatting very politely to him. You came in, and then you went and spoke to them. In what world does it look like I'm the one that's been aggressive? And I've sat there. I've got security in front of me, hands in my face. And I don't think they were all there, but all 3 of them surrounding me doing that, moving their camera in my face, in what world does that look like I'm being aggressive?
All I will say, okay.
But you should be good at assessing a situation, Constable.
You're aware that we have a national decision-making model?
Yes.
Yep. So we go into a location, as you say, we assess what we've got in front of us. Yes, you may be sat down. Yes, you may not be being abusive or whatnot at the time. I have an allegation from a member of the public stating that you've done X, Y, Z. I have to take that seriously. Don't have a duty about to investigate it. Like I'll be doing with the same allegations you've made. Yeah. However, hindsight's a wonderful thing, isn't it? If I'm not there, I've not seen what's happened. I can't say for sure. At the moment, I've got 3 against 1 telling me one thing, and you're telling me another thing. So I've got to go off what I've got. I
think it's completely wrong that instead of when the evidence is right there available to you, instead of checking the evidence, you've gone straight to invading my right to privacy. Okay. Because you may say...
Sorry, what's this right to privacy?
My details that you've taken, stolen from me today, I will say.
Ascertained.
Stolen from me, I will say. Okay? Under fear of arrest, I've given them. That's stealing in my eyes. Yeah. Okay? So I will say stolen. My details that you've stolen from me today, when the evidence was there, you say it's not proportionate because it takes too much time, right? I say my right to privacy outweighs your ability to move on to the next job because they've made false allegations. That's my view. And the courts will see what the court's view on that is, because I will be suing you for this. I will be taking it to court. No worries. Again, twice I've won already, and you will be the third.
Okay. The officer warned the auditor that he could face arrest if he visits any other job center that day, effectively implying an informal ban. However, without formal bail conditions, a court order, or a clearly defined legal restriction, police generally do not have the authority to limit a person's lawful movement in public spaces based on hypothetical future actions. Framing it this way risks overstepping legal boundaries, turning speculation into enforcement. The situation underscores a distinction between legitimate preventive powers and informal threats that exceed statutory authority, raising important questions about proportionality and lawful limits on personal freedom.
And I won't be doing that, okay?
Wait, say that again. The offence that I'm alleging.
Yeah, so we're going to record it.
Yeah.
So it'll be on our systems.
Yeah.
And all I'm saying is I'm not going to take a statement for you at this point in time, because I've taken one from them.
So will somebody be in touch with me to take a statement?
Yeah, so somebody, obviously, we've got your email.
Yeah.
Phone number will be preferable, but email's fine if you want to leave it at that.
Well, trust me, I'm much more responsive on my email than my phone number.
Somebody should make contact with yourself. Obviously, it's a counter allegation at this stage, so...
Well, it's not. They're two separate. Then that's not counter, is it? I'm not saying, this but that. They've made an allegation, fine, but I'm making they're two separate individual apart. They're not counter.
They'll have to investigate it either way.
Yeah.
Like to say...
Wait for the sirens.
Sorry. So yeah, somebody made contact with you. I know obviously your address isn't on us, so that's fine.
Right.
So it'll be a email to yourself discussing next steps.
Okay.
What would presume will probably happen is you'll be invited in for a voluntary interview,
Right.
and you'll get to give your account that way anyway.
Right. Okay. So in terms of at the beginning when you said it wasn't proportionate to check an hour's worth of my footage, but you've just spent 45 minutes in there.
Taking a statement.
Yeah, but so you say it's not proportionate, but
I'm
it
not
wouldn't
gonna-
have
I'm not
needed to
gonna
be
sit
the
here
whole
and
hour.
watch-
It wouldn't need to be the whole hour.
Like I said, I'm not going to
but-
discuss the offence with you any further. Because there's an
exactly.
allegation being
Yeah.
made, and like I say, you'll have to be
Yeah,
invited in for a voluntary interview.
Right.
now.
Okay. And one more thing, I want to make another complaint which you can record for me.
Yeah.
A member of the public that was in there came up to me, called me a "see you next Tuesday" multiple times. I did tell you why you're in there, but you didn't listen.
Okay.
Yeah, multiple times threatened
Right.
to, take me outside himself. If
Okay.
if he sees me outside, we'll be rolling around on the floor. It'll be a
Right.
different matter. He literally came in while you were in there, but obviously I didn't want to go in there to grab you because I didn't want you to then arrest me for breach of the
Okay.
peace. But he's a claimant in there. They'll have all his details on record,
Okay,
so you can get
okay,
his details from him. I can show you a picture now. I can email that across to you.
Yeah, if you want to do that,
Yeah.
that's fine.
So I'll show you who he is, just in case you do see him around. Bear with me, guys. No, I don't think there's anything else I need from you right now, other than,
Wonderful stuff.
said I've got all
I
your
can do,
details
like I
on
say, is
camera.
advise you not to go back in there. Obviously,
Yeah.
I don't want to have to come back here. If we do, then we are going to have to arrest you.
I won't be going back in there. Don't worry, I'm going to be heading on. I literally just waited to see what happened in
Excellent,
there.
okay.
But yeah, just be expecting a lawsuit. Be
No worries.
expecting complaints. You've actually been very quiet, and I think it's because you know he's messed up. But
Okay.
you particularly are going to be getting a complaint through IOPC.
Okay.
It will have to be sub judice to the lawsuit. Lawsuit will come first.
Yep.
Then you'll be getting a complaint through IOPC.
Okay.
I would not be expected to be keeping your job for, much more longer than a year. It's usually how long it takes.
All right, look,
So put yourself
All right.
on notice,
thank you very
Constable.
much for your time then, sir.
Yeah, no
Cheers.
worries. You can bugger off now.
After 45 minutes, the officer returns and admits he spent the entire time with security, yet still has not reviewed the auditor's footage, the very evidence that could corroborate or clear his account. This reinforces a perception of bias and confirms that the investigation was one-sided from the outset. Key takeaways from this encounter are clear. First, always request that officers state the specific legal power being used to detain you immediately. Second, a breach of the peace requires imminent harm, not mere annoyance or trespass. Third, police have a duty to investigate both sides of dispute, not just the caller's version. This breakdown is intended for educational purposes, not as legal advice. Always consult local laws. If you found this analysis useful, subscribe for more detailed audits and forensic reviews.